in lieu of having an officer get up there and say that, they'll actually exchange the whole file. They'll give us the file and we can review the file depending on the district attorney. They'll let us actually see the evidence. There's a couple of things that occur there. It's if you win the prelim and the judge says, you know what, you made a fine point, Mr. Clark. He forgot to say it occurred in Madison County. They slipped up. I'm going to dismiss the case. Your client charges are dismissed. It's usually not a good move because what's going to happen is the next step in your case, the DA is going to do it anyways. They're going to take your case to the grand jury, and the grand jury is going to hear the officer say, walked up to the handsome man, struck him in the face, caused injury, took place here in Madison County. At that point, your client gets indicted, and guess what? He gets rearrested, and you go back to that bond, you got to make another bond. If you just let the case go forward and you let the probable cause happen and judge binds you over and then you get arrested, you don't have to get it gets probable cause and the grand jury indicts you, you don't get rearrested. If you contest it and the judge finds that there's no probable cause and the case gets dismissed, the district attorney's office is completely free and it's completely fine for them to take the case to the grand jury and just indict you anyways, and you can end up having to get rearrested and make bond again.
I was just going to say, if you two were the only ones present, no witnesses or anything, is there, I mean, he can still file a charge, but would never get off the ground, would it?
The question is, on a one-on-one case, would it get off the ground? Absolutely, it'll get off the ground, because when you think about it, rape case, most rape cases are going to be one-on-one.
They do a rape kit at the hospital there.
Right.
He doesn't have any marks on him because you just slapped him good.
Yeah. The question is, again, about one-on-one, it all comes down to credibility of the witnesses, and it all comes down to the facts of each case. But each case is different. And but back to the point about being rearrested, we have this happens sometimes with drug cases. And I think I've got a client right now that we got the case dismissed on a $250,000 bond. And if the case comes back up, then she's going to have to make another $250,000 bond. And it gets pretty scary. And you hopefully you can convince them to not bring the case back up. And you roll the dice on some of these cases. And there's no guarantees of anything. But those bonding companies are very, very kind and forgiving people, because what happens generally is you don't put up, it's like 10% usually. Say on a $250,000, it may be a contract for $25,000. You're making payments. You're not putting up the whole $25,000. So the fact that the case got dismissed, they're not going to say, well, you got your case dismissed. You paid us $2,000. We'll forgive the other $23,000. You're obligated for that whole amount, even though the case got dismissed. So if they rearrest your client, and then they want you to put up a whole new $25,000 agreement. So it's hard out there on the streets. Fortunately, I just represent innocent people. Judges and juries have disagreed with me, but question, sir?
The Amy Bishop case, she used a court-appointed attorney.
I believe she had 3 of them. Amy Bishop is the UAH professor. Yeah.
She had to pay their fee?
The minute she gets out of jail, part of her probation would be to start paying back her, I'm assuming, I'm not familiar with the terms of it, but the standard order is that upon your release from prison, you start paying back the, I don't believe she has a release date. I think she got life without, so.
I know this is a little bit off track, but on that, she pleaded guilty. Now she's appealing her own guilty plea. How do you do that?
The question is, how do you appeal a guilty plea? There's any number of ways. You can say that, and I don't know the particulars of this particular woman's plea, but what you can do is you can say my counsel was ineffective, or I wasn't in the right state of mind when I pled guilty.
Do you ever receive back the bond money?
If you post your own, sometimes you can. But like if you pay a bondsman, no, the bondsman keeps, you're just paying the bondsman a portion. I'm glad you asked. Juvenile court is over on Cook Ave. Where is juvenile court? The question is, where is juvenile court? Juvenile court is over on Cook Avenue. It used to be the barbecue place, and it doesn't even smell like it anymore. It's juvenile referee Callaway runs it on Cook Avenue, and it's right next door to the Neves Davis Center, where Jacques Cawthorn is the head of the Neves Davis Center. And I did a large part of my practice over there. I used to, and I just love it. They do great work over there. They really do. Okay. As far as the prelim, though, the rule is you'll never see me or almost any attorney put their client on at the prelim. There's just no point in doing it. You never show your hand. The grand jury, same thing. Don't let your client go to the grand jury. One of the first, learning stuff. So I'm in the Air Force. I can't tell you the kid's name. He's probably moved up here by now. And it's just like, they want to interview my client. So I interview him for probably half hour. I'm beating him up. And it's just like, I think I got him every which way. There's no way they're going to flip this kid. I go over there, and we meet with the interviewer, the investigator at the Air Force Base down at Keesler. 2 minutes later, they got him in so many lies. You know, if, you know, they'd worked with the kid for a year, so they knew, you know, he couldn't tell the truth if his life depended on it. I'd met with him for 2 hours, and he was able to convince me that he was telling the truth. And, you know, it was just one of those sad things. And usually the investigators that are working in cases for long periods of time, they just know so many things, and you just don't. And I've had a couple of cases where I've let my clients go in there and talk, and you just have to. You're up against the wall, and you really have to. But for the most part, absolutely not. You don't. And I learned the hard way on that one, and he was the last one that I let talk to during my time in the Air Force when I was a defense attorney. But technically, you can let your clients go to the grand jury. I've been here for 13 years. I've never had anybody go to grand jury, never wanted anybody to go to grand jury. You let them go in there, you're not there, they can talk. I'm sure the DAs would be thrilled if I let my people go up there. Okay. After the grand jury, they get indicted. Then they're coming up on trial. That's where you go. So you've gone from district court with a felony exam, prelim, you go to the grand jury. If they get indicted, it's called the true bill. If they don't get indicted, it's called the no bill. Well, if they get indicted, it's true billed. And then you're coming to circuit court. That's the higher court. And what you're going to do is come up on arraignment. And some counties, they say arraignment. I think Morgan County will do that. You get arraigned maybe a month before your trial. Madison County Court, we get arraigned about 2 minutes before your trial. I mean, the jury's coming down the elevator and you're getting arraigned. It's kind of interesting. Federal court, I do a fair amount of federal work. I tried one back in, I think, January 7th. I tried a federal jury trial. And federal court does it backwards. State court, they arrest you, and then they spend a fair amount of time, run their investigation, and then they indict you, and then try you. It's about 1 year to 2 usually, until you get to trial, from the date of the arrest to your trial. It might be 1.5 years to 2 years. Federal court, they'll run that investigation. You may not even know what's going on, unless you're a business and they're subpoenaing your records. They're investigating you, and then one day you get a letter, come on over to court. And you show up at court, they hand you your indictment, you're indicted, and you got a trial in 90 days. And watch out, it's on. And the one that I did, January 7th, I think he was indicted in November. And from the date of indictment to trial, I think it was probably 70-something days. He was incarcerated, but it was 70 days from start to finish.
Well, you're entitled to a speedy trial.
Yeah.
Within 90 days.
Yeah, but a lot of people don't want that. Yes, but let's be reasonable though. 70 days. Whew.
On the state system, why does it take so long?
So a lot of it's economics. Right now, I think from what I understood, we have 10 labs. We used to have 10 labs to test the drugs. My numbers might be off a little. I believe we're down to 6. So you've had this huge backlog. And so you have the same amount of drugs, people using the drugs, but you can't go forward on the cases. And I'm sorry, the question was, why does it take so long for the backlog? Is because if you've got the same amount of people or even more using drugs, and now you only got 2/3 the number of labs testing the drugs, then the backlog is just going to get longer and longer. So there's a real push right now to use alternatives to prisons too. So it's just, but we got to do more with less. And when you do that, things just take longer and longer. I'm working harder than ever, and just can't see the end of the tunnel out there. So state court though, some counties they do arraignment separate. Here in Madison County, my client tomorrow morning, I would think 9 o'clock we're going to get arraigned, and 5 minutes later the jury will come down. If your client motions, a lot of motions need to be done right then. Some of the motions we do are motions to suppress. The famous one is Miranda, and that's one of the reasons I love being a defense attorney. It's not the prosecutors that do Miranda, created the laws under Miranda, and like I said, you defend the people that had unfortunately had killed the babies and all these horrible things, but those are the people that make the famous laws that give us our rights, like the right to remain silent, the right to be free from unlawful search and seizures. And it's, the angels, you don't get those cases off of angels. And so what you do is you get these cases and you have to scour the evidence and try and figure out through the cryptic notes what's going on. And it's fascinating because you might have a case for 3 years and you've got some of them hundreds of pages and others 1 page. And like I said, little cryptic notes. And you're sitting there and you're waiting and waiting, and you file your motion and the trial's about to begin, and maybe, just then the judge will say, okay, we're going to give your motion, and 1 or 2 officers will show up. And you're just waiting to see what they're going to say because you've had these notes and you've been staring at that note for that 1 page of notes for 2 to 3 years. And then the officers take the stand. It's like, oh, okay, it all come together now. And what he meant when he said this was this. And you've got to be sitting there thinking, okay, the law is this. He says this. Does that implicate this? And John and I tried a murder case last May. And it was the most confusing set of facts. I think there was 5 police officers responded. And we just had an overabundance of facts. And it was the most convoluted thing in the world. But when those 5 officers took the stand, it was just like everything just came together. And we still thought it was an unlawful interrogation. And we followed it all. And, but they convinced the judge, at least her, not me, they convinced her that what they did was right. But it's just interesting because, like I said, it's on paper and it's not dynamic at all. It's just laying there and you're trying to read it. But when you get into court, you just got to sit there and, like I said, you're trying to keep 5 different people's versions of the fact, then what your clients told you of what actually took place and the law, and trying to keep it all together. Then you got to convince the judge that your way is right. The DA is trying to convince them their way is right. It's fun. It's some fun stuff. But so right around time for arraignment, that's when you're going to do your motion to suppress evidence. I had one case recently, and it was kind of nice. I was able to suppress a little bit of evidence, and the officer admitted. He goes, I blew it. I should have read her rights. I should have done this and that. So I got half of it thrown out, and I'll talk about the motion for acquittal later on, but at the end of the state's case, that's when you do your motion for acquittal. And even though I didn't win the case by suppressing some of the evidence, later on when you do your motion for acquittal, and I'll explain that, I won the case on the motion for acquittal just because I got a little piece thrown out here, something else thrown out there, and later on it kind of gutted their whole case. And it's nice when it's like a jigsaw puzzle, everything comes together at the end. Talking about the actual jury trial itself, you bring the jury down, and get ready like I'm going to be doing tomorrow. I said about 9 o'clock. For me, what I tell my clients, and I've been taught this long time, my clients, 3 questions. You want to plead guilty or not guilty? You want a judge or a jury? It's always a jury. I think I've done 1 judge trial in 12 years here, and that was interesting. And the other one is when the state's rested and it's our time to come up, you testify or not. You want to sit on your hands and not say anything, or do you want to get there and testify in your thing? Every other decision is the attorney's decision. It's tactical. Everything else is strategy. I'm the attorney. I know what I'm doing. I'm not going to be second guessed, and this is the way it is. And ethically, those are the rules. And I have my questions, and if I had a notepad, I show you what I do is on the last page of my notepad on the cardboard, I'll have it written out there, your 3 decisions, sign, and that way, if they want to come back later on and say something, it's like, well, you made the decisions, here you go. And you're an advisor and a counselor, and you tell them, hey, it's a long shot, but if you want to take it, I'm here with you 100%. And like I said, this will be my 2nd one this month, and I think I average probably about 12 a year, which is higher than I think a lot. But you lose the majority of them, but at least you're giving them a shot, and if they want it, we'll take it. Yes, ma'am.
As defense attorney, are you ever tempted to lie?
The question is, as a defense attorney. No, I'm sorry. As a defense attorney, am I ever tempted to lie? No, and I can't let my clients lie either.
So you believe what your client tells you, and that is your basis of defense?
Well, the question is, do I believe what my client tells me? My job is I can't suborn perjury. That means I can't put on perjury. If I have a good faith belief that my client's lying, or I have reason to believe my client's lying, I need to investigate things. But no, I've never put on a lie. I've never put anybody on that I thought was lying, ever. I'm not going to, I'll put it this way. My career and my family, I'm not risking all this for any of my clients.
Doesn't it?
I'm sure it does. Yeah, but I'm not going to do it. I've got too much to lose, too much at stake. I enjoy this too much. I've been to the jail too many times too. I'm not going anywhere near there except for to visit.
How's plea bargaining working down here? Do you do a lot of?
Oh yeah, everybody. You got to have plea bargaining. The question is how plea bargaining work. Works great. That's the only way you can do it.
For juries then in a circuit court, kind of thing.
Why do we do juries?
Yeah.
Oh, because like I said, you got plenty of innocent people. Or cases that or cases the government,
The jury.
or cases where the government can't prove their case. The way the jury case starts is the first step is voir dire, and that's where we're questioning the jury. One of the things, state court, you're allowed to do a lot of questioning and actually try and shape them. My thing is just, it's the hardest step for me in the trial. You got to try and connect with a bunch of strangers, and you're sitting there next to a guy, and a lot of times they can sit there and tell you he's done horrible things. The case I told you about, the guy that dipped the child, I had a colonel. He was on that panel. He walked in. He tried as hard as he could to stay on it. Later on, he told me, did they convict that guy? He goes, I couldn't hardly stand it. He goes, I wanted to be on there so bad so I can convict him. I was like, so he lied. I had a colonel in the United States Air Force that lied under oath to stay on a jury, try and convict somebody that wasn't guilty of what he said. So, I mean, all sorts of people will lie.
It's a very competitive thing, isn't it, between the two lawyers?
Oh, the jury or trials, the question is it competitive? Unbelievably competitive. Okay. So the voir dire, though, what we do is we question people, and besides trying to find out information about who we'd want on the jury, we're also trying to shape the jury and get them our theme and our theory of the case. And we want to try and get out as much, not evidence, but our spin on the case. And they're trying to stop us. The judge is trying to stop us. I like to tell people how much I love the Founding Fathers. I take my family all over. Monticello, Montpelier. We were just in Philadelphia, Boston. And I go on, and then they start objecting to me. But it's like, you know what? That's where we got reasonable doubt. That's why we got, our jury trials. I mean, those people. I want those people to know I care about this stuff, and I'm as righteous and pious as the prosecutor, and that's my guy. You can't take my guy out. And sometimes it works. I mean, sometimes I can see their head shaking. Federal court, you get like one question, then they shut you down. We get to strike our juries. Then in the end, you're going to get like 12 people. 12. So that means if there's 30, then we each get to knock off a bunch to get it down to 12. Opening statements means that you get to give statements, you don't get to argue. Then if there's any motions, the judge is going to hear those. State puts on their case, then we get to put on our case. And at the end, like I said, if the state hasn't met their burden beyond a reasonable doubt, and I've got the jury in between my voir dire, where I've questioned them and told them all about burden of proof and beyond a reasonable doubt, and my open statement where I get them to promise again, and then at the close of the case, I say, hey, Judge, they didn't meet their burden of proof. And if I've knocked out a bunch of things with a motion to suppress, the judge might just grant that burden of proof or my motion for acquittal. If not, then the biggest part of the case for me is I can maybe put on some witnesses. A lot of times I don't have any. The question is, do I put on my client or not? Most of the time, the general rule is if all else fails, do it. But rarely do I put on my client because it's hard to put a client on who's not going to get tripped up. Then you do your final arguments. And my favorite illustration of this is Bob Becker, who's one of the great trial attorneys in the DA's office. He stood up and he said, Brian and I known each other for years. We get along great. Kids play soccer together. We go to the pool together. He goes, I'm going to sit down and just hear what he says because I get to go last. So I got up and I talked to Blue Streak and I went on. And so I sit down. He got up. He said, he's talking garbage. He goes, don't get distracted. He goes, his guy did it. They caught him. They caught him with a gun. He robbed these guys. Convict him. The jury came back in like 10 minutes. And you can't pull many over on him. The judge will instruct the jury. Jury deliberates. I tell you what, the truth is this. It's a hard thing. We got businesses. We're trying to run businesses, and the jury can be out 3-4 days. And you're sitting there and clients are calling you and yelling, where are you, where are you? And I'm sitting there, sitting on my hands in the courtroom for 3 or 4 days, and you can't do anything. You just sit there. You're trying to make small talk with your client, and you just know clients are going nuts on you. And then the verdict comes back. And the verdict means to speak the truth, and the juries do. And I'll say this, we've got a wonderful system, because I've been doing this for 21 years. And I would say a handful of times, I can't count on my hand, a couple times there's been what I'd say is some sort of injustice. But for the most part, jury does pretty well. And the system works, and it works really well. And I'm proud to be a part of it. I really am. And like I said, if anybody has any family members out there or anything that are interested, I'd advocate giving it a shot. Seems like yesterday I was in law school, and like I said, I was just in awe of getting into this thing. And it was the best decision I ever made. And I just love it. And it's hard work, but it's good work. And so the hard part is the sentencing. You get your verdict, and then you get sentenced. And I've had some, and you sit there and you get somebody, and the hardest part, like I'll wrap up with this, you have a right to pre-sentence investigation, and you sit there, and I've had a couple, like they say, life, and you watch your client, and you're sitting there, and judge says life, and you just say, we gave it a shot, and that's all you can do. So, we're out of time, I believe, so. And all you can do is you say, I gave it my best shot, and that's why you work so hard, because you want your client to know that you gave 100%. That's all we can do for them.